Welcome to a podcast from the 43rd Annual Conference of the National Center for the Study of Collective Bargaining in Higher Education and the Professions at Hunter College. The conference took place on April 3rd, 4th, and 5th of 2016 at the CUNY Graduate Center in New York City.
Well, we might as well start. Given that it's 45. Okay. Good afternoon. On this cold April afternoon in New York City. Welcome to the panel discussion on higher education issues at public sector labor relations boards. Today we're lucky to have three esteemed members of our panel, and I will get to introducing them right now. Marjorie Wittner is currently serving her second term as the chair of the Commonwealth Employment Relations Board, the appellate body within the Massachusetts Department of Labor Relations. Marjorie previously served as chief counsel and chief hearing officer in DLR's predecessor, the Massachusetts Labor Relations Commission. Can you speak up just a little, please? You're heckling me already? Okay, I'm sorry. Let's see. Okay. Tell me if you have any problems hearing me or any of the panelists. Okay. She served as a field examiner with the National Labor Relations Board, Region 2, and practiced labor and employment law for firms located in New York and Massachusetts. Ms. Wittner currently sits on the executive board of the Association of Labor Relations Agencies and is the former executive director of the New England Consortium of State Labor Relations Agencies. Marjorie is a graduate of Brandeis University and NYU School of Law. She also received an MILR degree from Cornell University and is a proud graduate of Hunter College High School. Our second panelist, John Winerius in the middle, is the current deputy chair and general counsel of the New York State Public Employment Relations Board, a position he has held since 2014. Prior to that, John spent 8 years as deputy general counsel of the New York City Office of Collective Bargaining. A 1990 graduate of Columbia Law School, he represented the city of New York as an assistant corporation counsel and teachers and a staff attorney for the New York State United Teachers. And Rhynard is currently serving his second term as a member of the Oregon Employment Relations Board, having just been reappointed to a 4-year term effective October 1st, 2015. Before being appointed to the Employment Relations Board, he served as a staff attorney for the Oregon Workers' Compensation Board, and before that he practiced extensively in the areas of labor, employment, and campaign finance law, primarily in New York. He received his JD from Northeastern University School of Law and his BFA and MA from the University of Arizona. My name is Phillip Maier. I'm the moderator of this program, and what we're going to do today is have these panelists present their discussions on various issues and topics about higher education issues in the labor relations field. Each panelist will have approximately 20 minutes, and they've advised that if you wish to ask any questions during their presentation, that's fine, or if you want to save them for the end, that's also fine. Again, if anybody has any problems hearing anybody, just let me know, or just let the panel know, and if there's any questions, feel free to ask at the appropriate time. Marjorie?
Good afternoon. Thank you all for coming out. I think this is the first presentation I've ever given on a Sunday afternoon. So we'll see how it goes. And thanks for the nice introduction, Phil. What I'm going to do today will require me to speak quickly because I'm going to just give a quick overview of the Department of Labor Relations in Massachusetts, our structure, and a few of the key facts that may make my labor relations agency a little bit different from Adams and John's. And I'm going to touch on a smorgasbord of 4 topics through which some of these themes are going to be repeated. A history of student organizing through the lens of UMass, a history of part-time and continuing ed bargaining unit determinations, again using UMass as the example to explain some of our principles. A little bit on faculty unit composition, particularly with whether department heads should be included or not in faculty units. And finally, if there's time, I'll switch to just an interesting case we decided a couple of years ago about the mandatory scope of bargaining in higher education. A particularly interesting case regarding the enforceability of a provision about the ratio of full-time to part-time employees at the State Board of Education. So the handout that I gave you today, which is, yes, okay, well, not there yet, but actually I'll go back. The handout that I gave you, I will be the next slide, but I won't be going over it in detail. It was just that I gave a dress rehearsal of this presentation to my staff on Friday, and they said, this doesn't help us when you're trying to explain where the various faculty and students are organized. Please make another slide. So I listened to them, and that's the handout that you have. So just a brief overview of the DLR. Full collective bargaining rights were granted to most public employees in Massachusetts in 1973. Unlike the private sector, we do include supervisors. Of course, that doesn't mean that supervisors are placed in the same unit with the employees that they supervise, but supervisors are not statutorily excluded in Massachusetts. In Massachusetts, like New York, but I think unlike Oregon, public employees have no right to strike. We also do not have binding interest arbitration, except for public safety, fire, and police, but even then it's not full binding interest arbitration. Any award that results from a tripartite arbitration panel still has to be funded through the appropriate funding agency in the state. Structure of our agency, we have attorneys and we have mediators. Our attorneys serve as investigators, and like the NLRB, when charges come through the door, there is a probable cause screening that can result in either dismissal or a complaint. Our hearing officers, then, if it does go forward to a hearing, will conduct a ULP hearing, and then we also conduct representation hearings. The dismissals and the decisions are appealable, and they are appealable to my board, the Commonwealth Employment Relations Board, which was created really in 2007. Prior to that, there was a different structure under the Labor Relations Commission. And my board is a three-person board. It's not a tripartite board per se. The statute does require only two to be from the same political party, though, which is somewhat interesting. I am the full-time chair, and I have two per diem members. Our decisions, in turn, are appealable to the state's appeal courts. And then finally, and this will come up later, we have had a version of card checks since 2007, and I'd like to say that the sky has not fallen. So this is the slide that's your handout, and I just inserted that, but we'll go over that a little differently. So the first topic I'm going to touch on is just a history of the bargaining rights of student employees in Massachusetts. So in 1976, the SERB, and I'm going to refer to it as the SERB even though it was the Labor Relations Commission, and it first considered whether student status and employee status can coexist, and they did it in the context of the City of Cambridge Hospital, and it was about the medical students who were also serving as what they called house residents, but as we would know as interns or residents. And the statement was made that the fact that medical interns and residents can be students for some purposes and employees for others should not deprive them of their rights under Chapter 150B. And it's in that case that the agency first adopted a case-by-case approach. And the overarching question was this: whether employee status rises to a level significant enough to affect the policies of the law and thereby come within the ambit of its protection. And they determined that yes, these House officers should be granted collective bargaining rights. And they said the fact that they receive an educational benefit can't overcome the fact that why are they getting paid? They're performing patient care functions. And in other words, they're getting paid to take care of the patients, not to use the students. So a few years later was the first time that the agency considered the collective bargaining rights of grad students, and this was at the University of Massachusetts at Amherst. And it was an interesting decision. It was decided by two commissioners, each on different grounds. And it's amazing how back in 1979, if you go back and read the decision, certainly it echoes very similarly the same considerations that were addressed by the NLRB in the NYU and Brown cases. But they kind of got there in different places. So the first commissioner essentially conceded that they were statutory employees, but what he decided was that the unit itself was inappropriate, and he took issues that they were students at the same institution that was employing them, and that was the distinction that was drawn between the House officers, because they weren't going to school. Those doctors were not going to school at the City of Cambridge Hospital. They simply happened to be medical students who were performing work there. And they did mention, however, that if in fact different policy considerations change, they might reach a different result. The second commissioner found that they in fact were not even statutory employees. And it was the first time that this notion of looking at both objective and subjective considerations of student employee status was considered. And the objective considerations are taxes paid out, or you're subject to workers' compensation. The subjective considerations is how is the school treating them? Are they being treated more like students, or are they being treated more like employees? And when you read the decision, you can almost hear the incredulity in the commissioner's voice when going over the facts. It looked like they were barely supervised at all. And I think as in their capacity, these grad students were barely supervised at all in their capacity as teaching assistants or research assistants. And it was that factor, I think, that he said, they're not employees, they're just students. So then we jump ahead to 1991, and it's, I'm not sure if anybody is in the room here from UMass or has any historical knowledge, but in 1991, what happened was that the university, on the basis of an election, voluntarily recognized the grad students. And that sort of set the stage then for the next decision in 1994, where it was the same union. I'm sure many of you are familiar with the UAW and the Graduate Employee Organization decided to organize the grad students at UMass Lowell. So the CERB then revisited their 1979 decision and concluded that both the TAs and the RAs were public employees, that a unit comprised of those employees is an appropriate unit. And that decision set up the framework of all of our subsequent decisions in determining whether or not students should be granted collective bargaining rights. And what's so interesting is when I looked at this, these four considerations are the same four considerations that the NLRB just asked for comment on when it was seeking amicus briefs. Its review now of the NYU petitions. And the first question is whether students fall within the statutory definition of employee, whether or not they're casual or temporary, is the proposed unit an appropriate unit, and then this is kind of the bigger policy issue, is the fact that they're students at the same institution that employs them preclude them from exercising collective bargaining rights. So, turning to the 1994 decision, I kind of broke it down for you. And so, employee status, they found yes, but I think what was very interesting is that unlike in subsequent cases, UMass didn't even contest it. They said, sure, they're statutory employees. Well, that, of course, makes the decision a lot easier to render when you don't have the employer objecting to that. And they looked, again, at the subjective and objective considerations that I talked about before. Casual employees, I won't go over that. Our considerations generally in casual employees is whether or not there's an expectation of continued employment, and it could be for, as short as 2 semesters, and is the employment going to be regular over the course of a given period of time? So, when you have the time, if you want to go back and look at it, but in this case we found that they were not casual employees. What is the appropriate bargaining unit? The CERB considered should it be all of UMass throughout the state as a single campus appropriate, and based on bargaining history, they said fine, a single UMass campus is appropriate. And the policy considerations were quite similar, and again, part of it drew from the fact that the employer really took a neutral stance on this one. The employer didn't say that there's going to be terrible interference with the academic components of these graduate students' careers if, in fact, we grant them collective bargaining rights. So the CERB declined to infer any negative impact. And in terms of, they went a little further, though, and said, you know, in terms of bargaining over permissive or mandatory subjects of bargaining, you know, we had that dichotomy. So should, in fact, the grad students propose something that's permissive, this dichotomy that had been established for all of the public employees since 1979 would take effect. And finally, they did say something interesting, that since 1979, it had been the policy to allow employees to decide for themselves whether or not they wanted to bargain, even if the scope of bargaining might be narrower than it might be in a traditional city or town situation. So the next case we had was a fun one because, well, first of all, it's one of my first hearings. It was the undergrads at UMass Amherst, and these were the resident assistants and the community development assistants, and they were the upper class students who live in the dorms and try to do some programming and also enforce the various dorm rules. And in that case, we did grant them collective bargaining rights. The employee status was contested during the course of the hearing, but then for some reason in the post-hearing brief, they just conceded it, which is the hearing officer irritated me a little bit because we probably could have shaped a lot of them up hearing. But in any event, we went through the tests anyway and found just a tremendous amount of subjective criteria that these undergrads were really treated as employees and not students. They had a very thick employee manual, they were disciplined. There was really no question, at least in our mind. We found that they weren't casual. We also found it was an appropriate bargaining unit, it was the campus-specific unit. And we did find that bargaining rights would effectuate the purposes of the law because in this case, there was practically no overlap between their academic pursuits and what they did as kind of super babysitters, sounds patronizing, of the undergrads in the dorms. So 13 years later, we got yet another petition in for undergraduates. This was to add on to the undergraduate RA unit, and these were peer mentors. So you're moving a little bit more to something academic because the university created this position to give first-year students academic support. And in this case, unlike in any of the previous cases, UMass very vigorously contested whether or not they were employees. We went through the criteria, hewing very closely to the analysis that we had done in 2002 and determined that they were employees, and we determined that they were not casual, and as far as their academic duties, we said that they relate to other students' academic pursuits, not their own. And what was interesting, a little twist in that case, was that at the time, UMass was in the process of converting this peer mentor program into an actual single credit course, and they tried to persuade us that that should be sufficient to change the balance between are they more students or are they more employees. But we simply found it too speculative at the time, and we've been waiting for them to come back to us, and thus far they have. So that's the little mini history there. Turning now to another timeline of talking about the employees, both adjunct employees a little bit, and mostly about continuing ed employees who, as you know, teach the courses that are not part of the regular curriculum, but are the courses that are given when school when the regular classes are typically not in session. So from 1975 to 2000, throughout UMass, all the CPEs were unrepresented. And then in 2000, the grad student unit filed a petition with us seeking to represent the grad students who teach CPE, as well as every other unrepresented CPE faculty at UMass Amherst. So the faculty unit intervened, and the university did voluntarily recognize the faculty as the representative of the faculty members who were already in their unit who also taught continuing professional ed. So what that did was that they bargained a few provisions in the collective bargaining agreement specifically for CPE faculty. And then in 2001, the UAW amended their petition, and they wanted to get voluntary recognition from UMass Amherst for the grad students who do CPE, and that resulted in, I think, probably our only higher education strike petition. And what UAW did was they very publicly and on their website urged all the grad students teaching summer courses to turn their grades in 5 hours late, and which they did. And they made quite a show of marching out and turning in the grades 5 days late, 5 hours late. Big difference, 5 hours late, not 5 days late. And we decided that it wasn't a strike in Massachusetts. It's an unlawful withholding of services that you're expected to perform. And what really turned it for us was that 12 other students turned in their grades more than 5 hours late, and it was determined through the course of the hearing it had nothing to do with the organizing campaign. So at that point, we decided it wasn't really an enforced rule, and we dismissed the strike petition. So we did order an add-on election, and the union prevailed. So right now at UMass Amherst, the grad student union represents both regular grad students and CPE grad students. So then these cases just continue to go on and evolve. In 2010, actually this is different. Let me just go to the last one. In 2014, the faculty unit at UMass said, well, now we want to represent all of the CPE instructors who are not represented. So you have the grad students performing CPE represented by one union. The regular faculty members who teach CPE are represented by the faculty union. What about the rest? And they wanted to do it through unit clarification petitions and not through an election. And our unit clarification rules say if this group of employees existed at the time that the unit was first created, or if the parties have essentially agreed that they're going to be excluded from the unit, you're not going to be able to get in just through the accretion process. So we dismissed that petition. How am I doing on time?
You did pretty well.
Okay. So then the last
Can I just ask you a question?
Sure.
So what was the point of 5 hours? What was the union going to accomplish by having people turn the grades in 5 hours later?
They were trying to pressure the institution into just voluntarily recognizing without having to go to an election. They just wanted voluntary recognition. And they thought turning the grades in 5 hours later was skeptical.
Yeah.
Fair enough. So, just the history of the department head. Well, now we're turning away from students and into just faculty unit composition. So in 1976, I think the CERB issued probably a 50-page decision on what who should be included in the faculty unit at UMass, and they went through a lot of categories. The most hotly contested were department heads and adjuncts, and in fact, adjuncts who were paid were in fact deemed, they met certain criteria for hours, were deemed to be appropriately included in the faculty unit, and they have been so since 1976. But the issue in the department heads was the university claimed that they were supervisors, and if they were in the same unit with the people that they supervised, that this would create a conflict of interest. The Labor Relations Commission was not persuaded. It included the department heads. UMass tested the certification back in 1976 by refusing to bargain, claiming that any unit that had the supervisors in it was an inappropriate unit. And the parties settled this outside of the aegis of our agency by having the department heads hold a self-determination election, and they voted not to be included department heads. And so they were out from 1976, and the recognition clause specifically excluded them. There was nothing ambiguous about it. In 2014, the faculty unit at UMass filed a petition for an add-on election to get the department heads in, and after hearing the CERB dismissed this petition and went back to the 76 decision and just looked to determine whether or not their supervisory rights had changed significantly since 1976, such that including them would create problems in the unit. And we found that they did, based on a number of things. They found the department heads had tremendous autonomy in terms of hiring non-tenured faculty. They had, unlike in 76, they had control over 10% of the budget. They did a lot of assignment and scheduling. Back in 76, the CERB said, well, that's mainly clerical. We found that that was not the case. They handled first-level grievances. There was some evidence in the record of being able to punish and reward certain faculty members. So we decided best not to include them in the unit. And then because these things continuously involve, this year, the faculty unit filed a petition seeking to represent the department heads at UMass Boston in a separate unit. And as we speak, the mail ballots. I'm done.
You done?
I'm done.
Okay, it's good timing. Thank you. That was interesting. I was thinking, in my mind, I was thinking about differences between your board and the clerk's board. There's some differences.
Yeah, sure.
Yes. And to hear about those boards, you have John Rennie's.
So since I don't have a PowerPoint, can everyone hear me comfortably from where I am? Great. So in your materials, you'll find about a 20-page outline with several cases attached and with sections of our rules and our statute attached. So almost everything I'm going to say to you will be sort of a summary and riffing off those materials, which you might find helpful if you want to delve into the real details of the fascinating topic of determining negotiating units in higher education. It is possibly one that arouses some of the most passion of anything since, I don't know, what's the best way to cross-cut a slice of bread? But it's actually quite critical in the way the rights of employees are set and their expectations, as I think the two cases that I'm going to focus on in my presentation will give you a glimpse into. So the first thing I'm going to do is just flesh out some similarities and some differences between PERB and CERB. And it gets complicated because we have two CERBs to talk about. So I'm going to give you the very brief whistle-stop tour of PERB. The Public Employment Relations Board itself is an appellate body. It's the name of the agency overall, but the board itself, it has a full-time chair and two per diem members. Sounds a lot like the Commonwealth for right now, right? We have lower-level determinations are made, initial determinations, I should say, in both improper practices, our New York State term for ULPs, and for certifications and duties of fair representation cases, sufficiency by initially a director, and then the cases are heard in the first instance by administrative law judges. Only if exceptions are taken to the PERB itself, to the board itself, will they get a board decision. The statute we enforce are, in fact, two. First, the Public Employees Fair Employment Act, more commonly known as the Taylor Law. Once I was asked at a conference, who is Taylor and how did he get the law named after him? And although I did not know, a very experienced employee of our agency, our Director of Employment Practices and Representation Practice, did know. Taylor was someone who was willing to let his name go on the statute and thus obtain immortality. But that's really all of the contribution Taylor apparently made to the statute, so we can move on. The other statute that we enforce is the State Employees Employment Relations Act, which is a pre-National Labor Relations Act mini NLRA. It's a weird little statute that's actually quite fascinating. There's no statute of limitations. It has no duty of fair representation clause, because none of these things had been thought of when it was passed by the state of New York. When the State Employment Relations Board, SERB, was abolished, we inherited its jurisdiction and also, we believe, all but 2 of the existing copies of its decisions, making research extremely entertaining for the practitioner. We're working on putting these online in an effort to try to make life less painful for the practitioners, but at the moment we're sort of
Winging it.
winging it would be kind. We're actually the only ones who know what we're doing, and even we don't know what they're doing because there are no cross-reference tables. But now to public education, and higher education in particular. The Taylor Law, or the Act as we like to call it in our decisions, relates to only public education and thus only public higher education. In our board is, in a sense, the primary source of law here, because although we are subject to review by the courts, and depending on which of the 2 vehicles one takes, what's under New York State Civil Practice Law and Rules, Article 78, one can either make a claim that PERB acted without substantial evidence to support its factual findings, and that goes right to our intermediate appellate courts, the appellate division, or one can simply claim we were arbitrary, capricious, contrary to law, or irrational. Capricious is my favorite because it sounds fun. However, we are generally given deference as long as we are applying the Act or the Taylor Law. If we go into statutes other than the Act or the SERA, we are not afforded deference. And so when we apply statutes that relate to higher education or relate to other statutory imperatives of the state of New York, such as the ethics laws, we are not afforded deference. But in the core of our own administrative capability and experience, we are afforded broad deference by the Court of Appeals and the appellate divisions, unless they're finding we're being capricious, in which case we're not. So the first question is, in New York State, who in higher education is a public employee? Full-time faculty is obvious. Adjuncts would basically make clear sense. Graduate students have been held to be, or teaching assistants since at least 1991, have been found to be generally, when acting as assistants, as opposed to as students, to be public employees, and so entitled to the benefits of representation. Now, there are earlier cases, and you can find them, but they're generally at the administrative law judge or director level, and so the board really doesn't get full-time into this in all cases. You will find cases involving CUNY and SUNY, involving graduate students, but they're normally cases on which the facts are very compelling on the nature of the employee's responsibilities. It's safe to say now that graduate students acting in an employee capacity have full employment rights. Now, because of the nature of their work, of course, they don't have the long-term rights that other life career employees would have, but generally the analog works pretty closely. In determining the employee status, our State Ethics Commission, now renamed JCOPE, has actually followed PERB's guidance in determining who falls within the ethics rules and the ethics law, and thus the effect of PERB's rulings has been a little more than people might expect. So, for example, to be a teaching assistant and to be subject to the disclosure requirements of the public ethics law, or because of the 2-year revolving door provisions, or even the lifetime bar from employment, that can occur. There's a lifetime bar in matters that you have worked on that can apply to some assistants. And sometimes this can seem like a little bit of overkill, but it's the idea is that the statute should dovetail as much as possible and with as little conflict between them as possible. So PERB has the authority to determine representation status, and under our statute, Section 207 of the Act, we're given 3 factors to look at, and by case law we've clarified. So the statute itself. The definition of the unit shall correspond to a community of interest among the employees to be included in the unit. Sub B. The officials of government at the level of the unit shall have the power to agree or to make effective recommendations to other administrative authority, to the or to the legislative body with respect to the terms and conditions of employment upon which the employees desire to negotiate. And C. The unit shall be compatible with the joint responsibilities of the public employer and the public employees to serve the public. Nice, clear, and precise. We know exactly how to do a unit definition, right? As a matter of common law over the decades, PERB has found 3 factors, 2 of which are the primary factors, and a third which is sort of subsidiary. The primary factor, and really one that PERB has repeatedly found to be the paramount factor, is community of interest. The second factor, and a lesser factor, but still an important one, is administrative convenience. A third factor that sometimes comes into play but doesn't really stand on its own, so I consider it a sort of subsidiary one. You'll see in our more recent case that we're going to talk about, it plays a part, is bargaining history. Because the bargaining history can shed light on what the expectations of the parties are and can illuminate their actual interests as opposed to their expressed interests, as parties have lived into their roles over time. So what is a community of interest? PERB looks at 6 factors. First, similarities of terms and conditions of employment, shared duties and responsibilities, qualifications, common work location, common supervision, actual or potential conflict of interest between members of the proposed units. In higher education, I think it's fair to say that the 6th one is the one that has, in the primary 2 cases that I'll be talking about, driven the bus. Conflict of interest. So bear that in mind as we go on. The first of the 2 cases is Board of Higher Education of the City University of the City of New York, I beg your pardon. This was the entity that chartered CUNY and created CUNY and administered CUNY, and in that case, CUNY adjuncts were at issue. And they were found to not properly be included in the same bargaining unit as the full-time faculty. Now, this is not necessarily the case in all full-time, part-time employees under the Taylor Law. Quite frequently, you will find full-time and part-time police officers or other employees, firefighters, or even attorneys. You will find the City of New York, you can find attorneys who are represented, some of whom are per diem or part-time, and they're lumped into the same bargaining unit with full-time employees. And the reason is the first 5 factors. Common jobs. Adjuncts teach, full-time faculty teach. Common supervision. They're part of the same department quite frequently, et cetera, et cetera, et cetera. You can check the boxes. But Board of Higher Education of the City of New York turned on a finding of conflict of interest. And this is how the CUNY position was that they should all be in one bargaining unit because that would be highly administratively convenient. One collective bargaining agreement, you could address all contingencies, keep everything nice and simple in one convenient bundle of facts. However, the number of non-annual lecturers approached that of 75% of the full-time faculties. When you added the annual lecturers who were adjuncts, you had almost an equal number of non-tenure track, non-full-time faculty and full-time tenure-track faculty, which could lead to deadlock in voting. It could lead to two almost equal factions quarreling over how to prioritize the rights of the various parties. And so the difference of function and the potential conflict of interest between adjuncts and other part-time faculty and full-time faculty was found to be dispositive in the Board of Education case. I'm going to give you a short extract from the case because I think it will give you the idea of the thinking of the PERB board in 1969. The faculty rank status personnel, the board wrote, are the heart of the university. It might be compromising to their independence and to the very stability of the university for non-tenured instructional personnel in numbers almost equal to that of faculty rank status personnel to be included in the unit of faculty rank status personnel. We believe that differences between faculty rank status employees and non-annual lecturers, whether they teach more or less than 6 hours a week, that was a factor distinguishing employees in the case, are of sufficient magnitude to preclude their being placed in the same negotiating unit. Faculty rank status personnel are all permanent staff in that they are tenured or hold positions leading to tenure. The others are reappointed a semester at a time. Faculty rank status employees receive many and various fringe benefit, the cost and value of which are considerable. Non-annual lecturers, on the other hand, do not receive these fringe benefits. Faculty rank status personnel exercise important responsibilities regarding the operation of the university by their service on departmental committees. Footnote, the rest of the earlier in the opinion there is reference to what would now be known as the shared governance functions of faculty members who are tenured or tenure track. Faculty rank personnel have their primary personal commitment to the city university. Non-annual lecturers, on the other hand, are likely to be full-time high school teachers working at the university at night, or businessmen, accountant, lawyers, or graduate student whose primary professional commitments are elsewhere. Now, the PERB board then referenced the fact that the most cogent argument against the allocation of faculty rank status personnel and non-annual lecturers to distinct units is the fact that both have the same primary assignment, that is to teach, and that these differences do not alone warrant fragmentation. So it ordered down to two things. One, the possible impairment through collective bargaining of the ability of faculty rank, to use the 1969 term, personnel, of their ability to serve their higher university function, and two, the possible conflict of interest between the two groups. Now, in a more recent decision, just this year as a matter of fact, the PERB board in Cayuga Community College, which is also included in your materials, reaffirmed Board of Higher Ed, despite the fact that the college argued to PERB that Board of Higher Education had not stood the test of time. They cited several decisions to the PERB board, two from the director and one from an administrative law judge. And in each of these cases, they argued that PERB had not followed Board of Higher Education, and therefore the case had been effectively overruled, that it was essentially relegated to the dustbin of history. The board reaffirmed the decision. And it noted in that case that at Cayuga Community College, there were approximately 60 full-time or tenured or tenure-track positions and 200 adjuncts. And so the PERB board wrote that adding the adjunct faculty to the full-time faculty unit would effectively drown out the voice of the full-time faculty, who would, at a stroke, be outnumbered by a more than 3-to-1 ratio in their own unit. So, the other cases relied upon by the director, by the college, cited as decided by the director or the administrative law judge, were found to be not controlling because they didn't emanate from the PERB board itself, but more importantly, not germane. Those were involved cases in which faculty, including adjunct faculty, had been afforded professional governance, university governance roles, shared governance type responsibility. They'd been on committees. They'd participated in all the functions. There were different structures of community college throughout the state of New York. And frankly, in those cases, the functions had varied from what was at issue at Cayuga, which was a situation in which adjuncts were not invited. And in fact, the handful of times they tried to turn up for committees were not allowed to participate. One was allowed to sit in and listen, was not allowed to vote or even to comment. Another wasn't even admitted to the meeting. So the question of the conflict of interest was recognized to still be powerful enough to prevent allowing these two factions, one which now overwhelmingly outnumbered the other, to become the only bargaining body, the bargaining unit that would comprise both. You had a question?
Yeah. What do you think the Pert Board would do if there was a unit that consisted of full-time faculty and adjuncts, and there was a fragmentation petition filed?
I think it would depend on the specific facts of the case, because remember, those older decisions, which were by the director and the ALJ at the ALJ level, were not followed, not purely because they weren't binding, but because the specific facts militated in favor of a common unit. So, for example, if one of those bargaining units is still functioning the way it did in the 1970s, where the adjuncts participate in decision-making and shared governance involves adjunct as well as full-time faculty, the case for fragmentation, I think, would be much less strong than was the case for not accreting the adjuncts in Cayuga. Also, I think the sheer overwhelming numerosity of the adjuncts was a major factor for the board in Cayuga. Finally, there was this. The 200 adjuncts were found to be capable of becoming a strong negotiating body in their own right. If you think about it, that's a good number of people, and that's a number of people that can negotiate effectively on their own. So those factors were the key factors in Cayuga Community College. Now, in future decisions, we'll see where the board goes with this. There are a number of cases, for example, where the parties have agreed to units that include both adjunct and faculty and full-time tenured faculty, and those arrangements will continue unless fragmentation petition is brought and unless the factual circumstances warrant fragmentation. But for now, the Board of Higher Education decision, as reaffirmed by the PERB board, remains and states the law that PERB will be applying, at least in cases that are factually of this make. And I think it makes sense, not to defend the policy behind the decision, but if you think about it, the concerns of adjuncts and the concerns of full-time faculty are quite different. And ironically, it seems to me that the interests of both are served better unless you're looking at a shared governance model or a shared participation model, as in those 1970s cases. But in the model which we see so often, where adjuncts are going frequently working at 3 separate colleges or 2 separate universities and doing some part-time here and part-time there to compile a full-time portfolio, their interests will be genuinely different and distinct from that of the full-time faculty. So I'll throw it open for questions if you have any. May.
My name is Risa Lieberwitz. I'm a general counsel for the AUP. I think that your last point is an interesting one. And obviously these are very difficult questions because universities have created these conditions in which you have exploited adjunct faculty oftentimes and who don't have the objective conditions, working conditions of tenured and tenure-track faculty. But I think philosophically, underlying your last statements about they really have different interests is kind of a static vision of the differences. So, for example, what if a union said, well, we want a petition for a mixed unit because we see adjunct and tenure-track faculty and tenured faculty as part of a broader vision in which we try to bargain so that the adjunct faculty will have greater opportunities to move into tenure-track lines, something like that, right? I mean, that's a different vision which rejects the conditions that have been imposed on faculty. So would that make a difference if the petitioner said,
I'm so glad you asked that question. I think it's an important one. And let me tell you why. The in Cayuga, the bargaining history was quite to the contrary. The parties had defined since 1972 in the recognition clause, and it kept getting reaffirmed and reaffirmed, that recognition was solely for full-time faculty, tenure track, or tenured. And so, plus there was testimony at the hearing that neither party wanted the units to be merged. Not, the adjuncts wanted to be represented by the Adjunct Faculty Association, the full-time faculty wanted to be represented by the Faculty Association. And so the only party that wanted them united was the college. And I don't mean to suggest that these cases are governed by a static vision. They're very fact-specific. As I mentioned, the 1970s cases may assuming those conditions still pertain, even though they were decided at the lower level and didn't go to the per board, would still remain good law. We look at the factors of common interests, commonality, and is there a conflict of interest. In Cayuga, there was both a felt and discernible conflict of interest, one that the per board could objectively find applied, and one that the adjuncts and the full-time faculty themselves felt. At one point when the adjuncts were first starting to organize, the full-time faculty were asked if they'd like to form a single unit, and they rejected the idea outright. As the adjuncts became more numerous, they rejected the idea as well. So if I gave the impression that Cayuga is a one-fits-all rule, I didn't mean to convey that at all. What I meant to say is that in a situation such as Cayuga, where you've got the questions of numerosity, different functions, different levels of engagement with the university, in that case, the Board of Education decision remains good law, the Board of Higher Education decision remains good law and states the norm for that fact pattern. So thank you for giving me a chance to clarify. And do I have time for one more, Phil? One more question?
My name's Oscar Harmon, University of Connecticut. Suppose you have that situation where you have both the contingent and the tenured in the same union. Can that union make an economic proposal that says flat raises only for contingent and percentage raises or merit raises only for tenure track?
It's an interesting question. Can it, you mean consonant with the duty of fair representation to both groups? I think that would depend upon the support of the membership and the nature of the extent to which that was a democratically run union, and plus the extent to which that accurately reflected the felt needs of the staff. It's very hard, the duty of fair representation is both a very high hurdle to surmount. The union is permitted to prioritize one group's interests over another, as long as it's doing so in good faith and belief that it's for the greater good of the whole union. But additionally, I'd say that it would depend upon a factor that would come into play is the extent to which the union is being responsive to the felt needs of its members. So in the absence of discrimination, bad faith, or arbitrary behavior, under New York State law, the duty of fair representation wouldn't be violated.
I don't want to step on Adam's shoes here, but one thing that I neglected to mention is we sort of have both models in Massachusetts now. So at UMass, the adjuncts, and at UMass Amherst, the adjuncts and the faculty have been in the same unit since '76. At UMass Lowell, they were traditionally excluded. And so what happened in 2010 is that UAW came in and said, we just want to represent the part-timers and the adjuncts. And they did it through a written majority authorization petition. And we went, because traditionally we do put part-timers in the same unit as full-timers. But one of the things that tipped the scales for us is that the faculty unit disclaimed all interest. They did not want to intervene. And so there's an example of where both parties are very happy to keep adjuncts separated, and so now they are separately represented at a different UMass campus.
As was the case in Cayuga, and I suppose I should relinquish over to Adam now.
Yep, Adam's turn. He's got a PowerPoint.
How's everyone doing? Good? All right. just going to very briefly give you an overview of Oregon's Public Employee Collective Bargaining Act, which we refer to as the PECBA. Like Massachusetts, it was enacted in 1973, and it's basically modeled on the NLRA. And so because of that, oftentimes we will look to the NLRA decisions as sort of guidance for our decisions, particularly pre-1973 decisions. The theory being that the legislature thought that they were modeling on the NLRA, they incorporated those sorts of concepts into the statute. Whether they did that or not is a different question, but that's the approach that we take. So again, public employees, and we also do some private sector employers and employees that are not covered by the NLRA's jurisdictional requirements. Very, very few fit that, but we do take those employees as well under our statute. So the board is a 3-member board. It's called often referred to as the ERB, which we now need to be careful about distinguishing about now that another ERB is legal in Oregon. But that's still what it's frequently referred to as. We have 3 administrative law judges who hear cases in the first instance. This is a situation where you have to file your unfair labor practice complaints or representation petitions. We don't have any, sort of arm like the NLRB does, where they go in and actually prosecute the matter. You bring it on yourselves. And then those ALJs issue recommended orders, which the parties can object to. And then it goes to a 3-person board of one of the 3 members. We also have conciliation services, which are basically mandatory there is an impasse in bargaining. And they do an incredible job of trying to resolve those disputes. As Marjorie indicated, with some limited exceptions, which are basically public safety and transit workers, public employees can strike in Oregon. Everyone else has binding interest arbitration. So if you can't strike, you get binding interest arbitration. And it's full binding interest arbitration, and it's often referred to actually as baseball arbitration, in that it's an all-or-nothing system. So if there are unresolved mandatory subjects of bargaining, both parties put those out there. The arbitrator cannot split or pick one, has to pick one offer or the other, which leads to some very interesting poison pill types of situations, as you can imagine. So it has its merits and demerits, but that's the system that we have. We do have card check, and that's the primary method for representation matters now. We used to do basically mail ballot, but most things now are basically card check. Almost everything that comes through recently in the last couple of years has been through card check. The statute was just amended to make clear that you can do card check for unit clarification petitions. That was a question before, and the board had found that the statute did not provide for that. The legislature then went in and fixed that and basically said you can do card check for anything. Yes?
Do you ever have situations where an employer alleges that the employees were coerced?
We've not had that situation litigated before us. So there is a provision in the statute, basically card check works, 50% or more have the cards. If 30% or more employees in the proposed unit want an election, they can then petition the board for an election, then an election will be held. But other than that, the statute expressly directs us to certify the unit of 50%.
And it's only for first units, right? You can't do it for ratings?
What's that?
You could use a card check if there's a rating?
We haven't been presented with that situation.
So our statute expressly prohibits
our statute
that.
does not
It's only for unrepresented employees can use card check.
And our statute does not have that express prohibition. We haven't been presented with that issue. So I'm going to just talk to you about 3 cases. I'm using this sort of model to talk about things that are going on, specifically significant issues that have come up related to higher education issues. And the first is the Coalition of Graduate Employees, Local 6069, versus the Oregon University System, or Oregon State University. So as a little bit of a background, in 1999, the union had petitioned to represent all graduate assistants at the universities, research assistants and teaching assistants. And citing an earlier 1977 ERB decision, the university objected to it on the grounds that graduate assistants who are teaching or performing research primarily to fulfill a degree requirement were not public employees. And in the 1999 case, there was a consent election agreement where the ERB certified a bargaining unit of graduate assistants that excluded those who were taught or performed research primarily to fulfill a degree requirement. So there's this distinction between types of graduate assistants who are public employees and those that are not, depending on whether or not those sorts of responsibilities and duties were part of a requirement to obtain a degree. So in 2012, the union filed this petition to add those previously excluded graduate assistants to the existing bargaining unit. So let me go back first to the 77 case that was sort of relied on, and that ultimately is overruled by this case, where it basically, again, said graduate assistants who teach or perform research that is not required to obtain a degree in performance services are employees, but the ones who do it because they need to fulfill a degree requirement are students and not employees. And the board reasoned that a traditional employer-employee relationship does not exist in that situation, even though they're paid a fee for a service, and they also added that at the time, that money earned from that service was not taxable income. So this 2013 case, board overruled the University of Oregon case. So this is a case where, I guess usually the University of Oregon has bragging rights over Oregon State University for football and basketball, but now Oregon State has the far more important bragging rights for beating U of O in the graduate assistant case. So the board noted that the earlier case really provided no explanation as to why these people were not, other than a summary statement that they're students and not employees, really no reasoned explanation as to why they're not employees. And they also noted that the Tax Reform Act of 1986 had really changed the tax treatment of stipends, so it was taxable regardless of whether your duties are part of a degree requirement or not. And the board reasoned that the definition of public employee is extremely broad, and the definition is an employee of a public employer. So, a little circular, but that's how the statute works, and it's only subject to specific legislative enumerated limitations, and those were not here. An employee is someone who performs services for another person in return for salary or wages under the control or right to control of an employer. The board found with little difficulty that these employees do that, so they're public employees under the statute. And they rejected the university's argument that it should follow the NLRB precedent in this case. And as I noted before, one of the difficulties that we have from time to time is the NLRB is not a static entity. And so with Adelphi University, then NYU, and then Brown, the question becomes, well, what should we look to if we're looking to NLRB cases? And we found because of that sort of inconsistency in those decisions, we weren't going to look to what was the current state of the law. Also noted that there was a pending notification from the board to brief whether they should overrule Brown University. The board also rejected the university's separate community of interest arguments. And again, under our statute, the language is an appropriate unit. Not expressly by statute, not the most appropriate unit, just an appropriate unit. So any unit that the board finds appropriate, and we have under the statute discretion to give how much weight to give each of these factors. And that can differ from case to case. In one case, we might find similarities, duties, skills, benefits is more important, and we're going to give that factor more weight than other sorts of factors. And we have broad deference with that respect. And we found that both of them are largely similar with respect to community of interest, regardless of whether they're doing it to fulfill a degree requirement or not, and that any differences were not sufficient to make the proposed unit inappropriate for bargaining. Again, the petitioner gets to decide, really gets to frame the issue in terms of, is this issue an appropriate unit? Not the most appropriate unit, but just an appropriate unit. Any questions on that case before I move on? Okay. So the next case, Western Oregon University versus Oregon University System, Western Oregon University. This was a unit clarification petition that's seeking to add instructors and coordinators in the intensive English program to an existing faculty unit. And these are folks who basically teach non-credit remedial courses in a non-degree granting program. And the university said, these people aren't faculty. They don't have an academic rank. They're not traditional faculty, so they shouldn't be in the existing faculty unit, and they don't share a sufficient community of interest with the current faculty unit, so they should be out. The board disagreed and found this was, again, an appropriate unit. It noted that historically what the board has done is it's divided up with higher education units, faculty or academic and professional ones, and non-faculty classified employees. And that's basically the distinction. And under our statute, we have a preference for certifying the largest appropriate unit and avoiding unit fragmentation. And so looking at those factors together, we looked at this faculty and found that it was consistent with our precedent in that matter, that they were teaching academic professional sorts of employees as opposed to non-academic. So we looked at other community of interest factors. Again, we just looked that they basically perform the same work they teach, especially with respect to non-tenured faculty. We did note that there's no interchange or transfer of duties between these employees and their faculties, but that's the same with other disciplines, right? You don't have history professors often teaching within the English department and that sort of thing. So there's not a lot of interchange with this particular program, but that wasn't inconsistent with the rest of the university. They both have similar access to university facilities and equipment. They have the same benefits and paid leave. And they schedule to work on an academic year, even though the IEP instructors might have a little bit more of a structured work schedule. It's basically the same. And we rejected the idea that just because it's non-credit, non-academic courses, that they don't share sufficient community of interest. And we noted that, some inherent difference in work is really really inherent in our objective to certify the largest appropriate unit, right? If you have that as sort of a mindset, you're going to have folks that have different duties and responsibilities and requirements, but that's sort of part of the deal. In exchange for that, the university doesn't have to bargain with 24 different bargaining units, right? We noted that similar, if not greater, differences exist within the current bargaining unit. For example, there are librarians in there who do not teach or do any of that sort of work, and so there's a lot of differences within the existing bargaining unit. And these IEP folks are not so different that it's not, again, an appropriate unit. And lastly, and this is an important point, we noted that the university had not identified a bargaining unit that would be appropriate for bargaining. They were saying, well, they can't be their own unit, they're too small. They don't belong in the faculty unit, they're not faculty. They don't belong in the non-professional classified employees. So, and under the PECBA, these folks have a right, if they want to be represented, to be represented. So the fact that they could not identify any group where these folks would fit, they kept saying, nope, that's not good. And we said, well, they get the right to have a union represent them if they want to. And so that, again, was a key factor, that they couldn't identify any group at all that they thought was appropriate for these folks to be in. Any questions on that before I move on to the last case? So a strike case, is that exciting? Yeah, strike case. So Portland State University, chapter AAUP versus Portland State University. This is an unfair labor practice complaint alleging that the university violated the PECBA by announcing 2 days before a strike authorization vote that the university would disable the login credentials to university-provided email and all other electronic accounts for any faculty that went on strike. And the board concluded that this announcement interfered with, restrained, or coerced employees in the exercise of protected rights under our statute. So this is 1,500 full-time faculty and academic professionors, and the university has a single sign-on system known as Odin. I don't know if this is common. Yes, laughter. So it provides them with all of their electronic access, their database, the student record-keeping system, email, research databases, a single logon system. So it's basically all or nothing. And the university made a big point about this, saying we can't just disable parts of it. It costs us $1 million. We can't do it. You basically either have access to it or you don't. And typically, the university would terminate an employee's access to his account within 24 hours of separation. But however, during unpaid leaves with absences, sabbaticals, FMLA, Oregon Medical Leave Act, suspensions, the university had not disabled employees' email accounts in these circumstances. So someone's out on sabbatical, they're gone, they're doing something else, they have not disabled their Odin access. Again, the university expressly expects faculty to accept invitations to serve on advisory bodies, public commissions, travel to conferences, do research, publish, those sorts of things, which was a big factor in our decision. So, strike authorization vote, March 11, 2014. The university, I'll sort of fast forward a little bit since we're close on time, basically sends out a FAQ, which says, we are treating the physical workplace and the virtual workplace the same. Just like if you're out on strike, you can't walk into your office and sit in there, you cannot log on to the Odin system. So if you decide to go out on strike, you will lose your access to do that so long as you stay out on strike. If you come back on strike, you get it back. But so long as you're out on strike, you cannot log in to your accounts. They also did some, similar thing with public spaces and identifying what are the public spaces of the campus, where they could come and where they could not go. You can't go into, you can go out in the main area, but you can't go into the buildings, that sort of thing. So lots of faculty sort of expressed concerns to the union saying, listen, this is a big deal. What if my students want to get in touch with me? I'm on strike. I don't have any email access. I have to submit any sort of grade requirements. I don't have the ability to do this. So the board concluded that the FAC violated the part of the PECBA that prohibits an employer from interfering with, restraining, or coercing an employee in the exercise of those rights. And we began with the well-settled principle that employees have a statutorily guaranteed right to engage in strike activity, and that includes voting for or against a strike. So under our precedent, the question is whether issuing that FAC 2 days before the strike authorization vote would, in our language, would objectively chill someone in the exercise of the protected activity. Now, because this is, you don't have to prove under our statute, under this prong, that it did chill the employees. The question is whether objectively what is natural and probable effect of that statement would chill someone. And we found that it did. We noted again that with respect to these employees, there was evidence in the record that they are highly dependent on access to the system, basically to do every part of their job. Also that this is not a traditional group of employees. This is not like a janitor who would probably be great. I don't check my email. I'm not checking my email. I'm not doing that. These are professional employees who have obligations that really go beyond sort of a 9-to-5 working environment, right? They have these, what we call these hybrid personal professional obligations as faculty to do that. And that's very critical to them, their professional careers in addition to being employees. And so telling them 2 days before that they would lose this access would naturally and probably chill them in the exercise of that right. And we rejected the university's two primary defenses. One is they said, well, they can just sign up for another email account. They can just get a Gmail account. Like, there's nothing, what's the problem? And we said, well, that's true, but it's not just the email account. It's a lot of other things. And there was also testimony to people like, this is the account I use. This is the account that my students have. They don't have my Gmail account or this other sort of account. And secondly, this was really the primary argument, is the university argued that, listen, we're just going to take a lawful action. We're just announcing a lawful action, and what's wrong with that? And we said, well, we didn't reach the issue of whether or not they could have done that. But we analogized it to another case that we had that involved a public school system where a school principal, again, I think it was the day before a strike authorization vote, told the teachers that you need to get me 2 weeks of lessons plans by tomorrow afternoon. We said, well, that's not objectively unlawful, I guess, but it had the quality of a reprisal because of the timing that it was issued, the way that it was issued, and we basically analogized that to this case. Based on the timing of it, the circumstances of it, sending that back out right before these folks were going to engage again in a statutorily protected activity and telling them that if they did something that they have a right to do under the statute, that they would lose this access that had the quality of a reprisal. And so we ordered them to cease and desist, and we also ordered them to post an email notice of the violation, which is something that we do as a remedy if it's the normal way that employers communicate with employees. Yes?
What's the status of the, what I assume is the expired agreement? Once the
The university has to maintain the status quo for all mandatory civics bargaining.
Have you ever had a lockout case?
We've not had a lockout case that I'm aware of. Certainly not
Did
with us.
anybody
No.
make the analogy that this was?
No one made the analogy that this was the equivalent to a lockout. Yes.
Along those lines, it seems like it was treating the faculty more like if they struck as if they'd been fired.
Correct. And that was a point that we did reiterate. I don't know if it came out in the decision, but we did come up in oral argument before the board, which is under the statute, when you are still an employee. And so the union had made this pitch again, like, listen, with other situations like sabbaticals and those where they're not really physically working, they're still employees. And under the statute, and you're striking, yes, you don't get to then go into your workplace and do that sort of, but you still retain your status as a public employee when you're doing that. So you could have made that argument that it was effectively Any other questions on?
Any further questions? For anybody? Everyone wants to go out and drink. Huh?
Yes.
Okay. Thank you very much.
This ends a podcast from the 43rd Annual Conference of the National Center for the Study of Collective Bargaining in Higher Education and the Professions at Hunter College in New York City.